Alright folks, buckle up because we're diving into the thrilling world of Arizona's Rule 4.1- Service of Process. Don't worry, it's not as dry as it sounds. This rule is basically the instruction manual for how someone gets served with legal papers in the state of Arizona, you know, those official documents that say, you're being sued, or you have to show up in court. Why should you care? Because if you're ever involved in a lawsuit in Arizona, understanding this rule can be the difference between winning and losing. It dictates how you let the other side know about the case, and trust me, you don't want to mess that up. It's like forgetting to RSVP to a wedding. Things get awkward fast. This rule is all about fairness. Everyone involved in a lawsuit deserves a chance to tell their side of the story. But that can only happen if they actually know they're being sued in the first place. That's where Rule 4.1 comes in. It lays out the proper procedures for serving legal documents, ensuring everyone gets a fair shake. So, whether you're a legal eagle or just someone who wants to be prepared, stick with me. We're about to break down this rule into bite-sized pieces so you can navigate the Arizona legal system like a pro. First things first, let's talk about jurisdiction. That's a fancy legal term for where you have the power to do something. In this case, we're talking about the power of the Arizona courts to make someone show up and defend themselves. Generally, Arizona courts can only order someone to appear if they live in Arizona, do business in Arizona, or did something naughty within Arizona's borders. Think of it like this. Arizona courts are like referees in a basketball game. They can only call fouls on players who are actually on the court. So, if you need to serve someone with legal papers in Arizona, Rule 4.1 says you usually have to do it within the state. There are a few exceptions, of course, but we'll get to those later. For now, just remember that Arizona courts have home court advantage. Now, how do you actually serve someone? Well, you can't just slip the lawsuit into their Netflix queue and hope for the best. Rule 4.1 lays out a few specific ways to serve someone, and you have to follow the rules carefully. The most common method is personal service. This means someone, over 18 and not involved in the case, personally delivers the documents to the person being served. Think of it like a high-stakes game of tag, but instead of yelling, "You're it," you're handing them legal papers. Other options include serving someone at their usual place of abode, their home, or by sending the documents via certified mail. The important thing is to choose a method that complies with Rule 4.1 and ensures the person being served actually receives the documents. Now, serving someone with legal papers can be a bit, shall we say, uncomfortable. It's not exactly how you want to make a first impression. Thankfully, there's a way to avoid the awkward encounter, the waiver of service. This is basically a legal, you've got mail notification. It's a document you can send to the other party asking them to waive their right to be formally served. They sign it, send it back, and boom, they've officially been served. No awkward encounters required. Why would anyone waive service? Well, for starters, it saves everyone time and money. No need to hire a process server or deal with the hassle of tracking someone down. Plus, it shows the court that everyone is cooperating and acting like adults. But here's the kicker. If someone refuses to waive service without a good reason, the court can actually make them pay for the cost of serving them the old-fashioned way. It's like refusing to use a coupon at the grocery store and then complaining about the price. So, waiving service is usually the best way to go. It's faster, cheaper, and avoids unnecessary drama. And who knows, maybe you can even get a thank you for understanding note in return. A guy can dream, right? Serving individuals might seem straightforward, but there are some nuances depending on who you're serving. For example, serving a minor, someone under 18, is a bit different. You can't just hand them the papers and say, "See you in court." In Arizona, you usually have to serve both the minor and their parent or guardian. This ensures the minor's interests are protected and that someone with legal capacity is aware of the lawsuit. It's like ordering pizza for a group of teenagers. You always make sure an adult is there to sign for it. Similarly, serving someone who is incapacitated, meaning they can't understand the legal proceedings due to a mental disability, also requires extra care. You'll need to serve the incapacitated person and their legal guardian or conservator. This ensures someone is looking out for their best interests in the lawsuit. In both cases, the goal is to make sure the person being served is treated fairly and that their rights are protected, even if they can't fully understand the legal process. Section 5. Uncle Sam needs his papers too, serving government bodies. Suing the government might seem daunting, like challenging a grizzly bear to a staring contest. But hey, sometimes it's necessary. The good news is that Rule 4.1 lays out a clear process for serving government entities too. If you're suing the state of Arizona, you need to serve the Arizona Attorney General's office. Think of them as the legal department for the state. They'll handle the lawsuit on behalf of the government. For lawsuits against a county, city, or town, you typically serve the city or town clerk. They're like the record keepers for the local government. And here's a fun fact. You usually have to send an extra copy of the summons and complaint to the government's attorney. It's like sending a courtesy copy to your boss, just to be safe. The bottom line is that serving a government entity isn't that different from serving an individual. You just need to make sure you're serving the right person in the right office. No need to deliver the papers on horseback while wearing a powdered wig, though that would be pretty epic. Section 6. Thinking outside the mailbox. Alternative means of service. Sometimes serving someone the traditional way is like trying to find a parking spot in downtown Phoenix during rush hour, nearly impossible. But don't worry, Rule 4.1 has a few backup plans. Alternative means of service. These methods are used when traditional methods, like personal service or certified mail, have failed or are impractical. For example, if someone is actively dodging the process server or their whereabouts are unknown, the court might allow you to serve them in a different way. One option is service by publication. This means publishing a notice of the lawsuit in a newspaper or other publication that the person being served is likely to see. It's like putting up a missing dog poster, but instead of a lost pet, you're trying to locate a defendant. Another option is service by certified mail with restricted delivery. This ensures the documents are only delivered to the person named on the envelope, not just anyone at their address. It's like sending a top-secret message that requires a fingerprint scan to open. The court will only allow alternative means of service if you can show that you've made diligent efforts to serve the person using traditional methods. It's like asking for extra credit. You have to prove you've done the regular work first. Section 7. Missing in action, service by publication explained. Now let's talk more about service by publication because it's a bit of a special snowflake. It's typically used as a last resort when all other methods of service have failed. To get permission for service by publication, you'll need to convince the court that the person you're trying to serve is intentionally avoiding service or that their whereabouts are truly unknown. Think of it like presenting a case to Sherlock Holmes. You need compelling evidence. If the court approves your request, you'll have to publish a notice of the lawsuit in a newspaper or other publication that circulates in the area where the person last resided or where the lawsuit is pending. The notice must include specific information about the lawsuit, like the names of the parties, the case number, and a deadline to respond. Service by publication isn't ideal because there's no guarantee the person you're trying to serve will actually see the notice. It's like leaving a message in a bottle and hoping it washes ashore. But it's sometimes the only option to move forward with a lawsuit when someone is MIA. It ensures the legal system doesn't come to a screeching halt just because someone is playing hide and seek. Section 8. Rule 4.1 in a nutshell. Key takeaways. Congratulations. You've made it through the wild world of Arizona's Rule 4.1. You're now basically a legal eagle, or at least you can pretend to be one at parties. Here are the key takeaways to remember. Service of process is essential. It's how you let someone know they're being sued and gives them a chance to respond. Follow the rules carefully. Rule 4.1 lays out specific procedures for serving different types of people and entities. Waiving service is usually the best option. It saves time, money, and avoids unnecessary drama. Alternative means of service are available when traditional methods fail, but you'll need the court's permission first. And there you have it, folks. You're now equipped to navigate the exciting world of service of process in Arizona. Just remember, if you're ever unsure about the rules, it's always best to consult with a legal professional, because when it comes to the law, it's better to be safe than sorry. And that's our show.